Thank you.
All right, thank you. All right, this is case number 24-175-317. This is Credit Acceptance Corporation versus D'Angelo Lee. Now, the matter is before the court, set for status conference. This is the first hearing regarding this matter. All right, your appearance for credit acceptance, please.
Good morning, Your Honor. Hannah McNeese, PA 2477 for the plaintiff.
Thank you, Ms. McNeese, and good morning to you. Thank you for your patience. I'm looking for D'Angelo Lee. If you're on the Zoom, please say something at this time.
Yes, good morning, Your Honor.
All right, thank you, Mr. Lee, and good morning to you, sir. So I've received a handwritten answer regarding this matter. Madam Counsel, did you receive Mr. Lee's answer?
I did, Your Honor. We did have a brief moment to speak this morning, and we do have a resolution in the form of a consent judgment we'd like to place on the record.
All right, and Ms. McNeese, you may proceed at this time, ma'am.
Thank you, Judge. So the suit amount was $12,233.69 plus court costs for a total judgment amount of $12,455.94. Mr. Lee is going to make $100 a month installment payments, with the first payment beginning April 15th, 2025, and then on the 15th of the month thereafter until paid in full. I did ask Mr. Lee if I could sign his name to the consent judgment based on the terms we placed on the record today, and also did inform him of the various ways to make a payment to our office.
All right, I presume that he gave you permission to proceed in that manner. Is that correct, sir? No, ma'am.
It is, Your Honor, yes.
All right. And Mr. Lee, I'm hearing that the parties have found a way to work this out with the entry of a consent judgment with a total amount of $12,455.94, and that amount will be paid in monthly installments of $100, with the first installment payment due on the 15th of April, and then on the 15th of each month thereafter until the is that in fact a consent agreement that you entered into, sir?
Yes, Your Honor.
Given that this is on the record now, you're okay with the plaintiff fixing your signature, knowing that it's a record of this matter on the court. Is that correct, sir? Is that correct, Mr. Lee?
Yes. Yes, Your Honor.
All right, the court then will accept the consent at this time, and I will sign that document once it's presented to the court. And Mr. Lee, I promise I won't sign it unless it says exactly what the parties agreed to. So I wish you well, and you'll receive a copy of the order from me in the next few days. Good day to you, sir. Thank you, counsel. I'll submit your order.
Thank you, Judge. Have a good week.
Okay, thank you.
Mr. Rusin, is that you there, sir?
That is, but I see that you've disabled my video according to my iPhone.
Yeah, we had bombers coming in today, so I had to.
Certain proof. I asked them for certain information so that I can include it into this identity theft case that I still currently have of someone who got a vehicle from Capital One as well in my name. And I have the proof of all of those things. So I asked them for certain.
Okay, let me stop. Okay, I cut you off because that's not responding to the complaint. You have something filed in court. You have to file a response in the time permitted by law in court. You have to answer the complaint. And so you're saying that you sent something to Midland. That doesn't mean anything. You didn't file a response to the complaint. And I guess what you're telling me is that the reason you didn't file a response to the complaint is that you thought that asking, putting something in writing to Midland, that was a sufficient basis. Is that what you're saying to me, ma'am? Come on off from mute. You're on mute now. You're on mute now. So
Okay,
come back
I'm
off.
sorry. What I'm saying is that when I responded to the court when I got something in the mail. I don't know what all they sent me. Whatever they sent me, I responded to the court. Whatever they sent me directly, I sent things to them years ago when I heard about this. So if there was something sent to me by the court, I didn't get whatever you saying. I responded. I didn't come to the court hearing because I was ill recently. Other than that, I didn't have any information about court or anything.
Okay, so ma'am, I'm not talking about recently. I'm talking about in 2023. This lawsuit was filed in 2023, and service was made at the Charlotte address. You did not
Okay.
respond. You did not respond to the complaint back in 2023 when this complaint was filed with the court. I have nothing
I
from
didn't get
you.
anything.
That's not what the file says. And then subsequent to that, at the same address, the court and the attorney would have sent you a copy of the default entry as well as the entry of the judgment in this matter, and you did not respond in a timely manner even to those things. That's my concern here. That's because that's the first part of the test, and it does
Yeah,
not
well,
seem.
I was living in Novi. I was living in Novi then, and I mean, I wasn't here. I always had this address here too, but I was living in Novi. So that's probably why I didn't get whatever you're saying that I get. My son goes to school there. So I didn't get that information, sir.
Yeah, but you're responsible for the address that you make available, ma'am. That's your address. And you
Correct.
know, if you don't check your mail, that's not really a reasonable excuse as to
Oh, I checked
why.
my mail. I didn't receive it. I didn't receive it, Your Honor. If you, okay, go ahead.
I don't know if I can get you over that hump. I'm having a hard time. I even put some feelers out there to try to get you over that hump. I don't know if I can get you over that hump. The other part of
Officer, but
your,
I have proof though.
what do you have proof of, ma'am?
I have proof that capital, like I have something right now stating here that on 11/27/2020, someone purchased a $42,000 car.
That this is not my case. But if you have a case, somebody files a lawsuit against you and you don't respond to that lawsuit and you sit around a couple of years and then you file and say, well, that's not me. You say, well, why didn't you respond to the complaint? I didn't respond because it wasn't me. Well, that don't work. The law doesn't allow me to set it aside just because you decided to wait 2 years. I have to see that there is a reason why you did not respond within the time required by law. I think that there is a sufficient basis that the defendant's illness may have contributed to her failure to respond in a timely manner. For that reason, I will find that there was good cause to set aside the default and that there is a likely meritorious defense of this matter. The default judgment will be set aside. The matter be set on for a pretrial date. All right, and so I'm going to set a next action date. As a matter of fact, why don't I set this up to discovery? And so I'm going to give it a 60-day discovery order. And the return date in this matter is going to be, just one moment here, that return date is going to be May the 28th, 5, 28, 29. That's a pre-trial conference date. I will send a pretrial scheduling order in the mail today. You'll get it in the next few days. It will allow discovery through May 28th. Then May 28th at 9:30 will be the time that the parties are required to be back in court. I wish both sides well. Good day to you.
Thank you, Judge.
Thank you. Good day to both. All right, this is case number 24241641. This is Ebony Dean versus Brian Butcher. The matter is before the court, set on for a hearing on a motion. Just one moment, let me make sure. The record should reflect this matter started in the small claims division of this court and was removed to the general civil division and is now before this court. It looks like the matter is set on for a motion for a summary disposition. All right, do I have Ebony Dean? Ebony Dean, if you're on the Zoom. Do I have Brian Butchart? If you're on the Zoom, say something at this time.
Good morning, Your Honor. Brian Butchart, P66250. I guess I'm in pro per today.
All right, thank you. Thank you, Mr. Butchart. It's good to see you, sir.
Likewise.
I don't know what side is on this. I know that we sent a notice out on February the 6th, setting this matter on for a hearing on a motion for summary disposition on today's date. And that notice went to the address provided by Ms. Dean on Foyer Street, in the city of Detroit. So, counsel, have you heard anything from Ms. Dean this morning? Have you received any written response to your motion? Any update?
The answer to both those questions, Your Honor, is no. I have not heard from her this morning, and I've not received a response to my motion.
All right, and your pleasure at this time, counsel.
Judge, at this time, I would ask the court to consider entry of an order granting my motion, particularly the motion that as it exists under C8. My understanding of the law is that a motion granted under C8 essentially would amount to a dismissal with prejudice. Certainly, if Ms. Dean wants to file a case against my client, she's entitled to do that, but I don't believe that there's any merit to the case against me. I think I've provided enough documentation along with my affidavit to the motion to indicate Ms. Dean was lawfully evicted from her unit. It's pretty clear from her affidavit and claim in small claims that she's alleging some damages as a result of that lawful eviction. Frankly, I'm not sure she would have any claim against my client, given that my client relied on the court process, but certainly it's even further attenuated that she would have any claims against me to the extent that I participated in the underlying case as the attorney of record for her former landlord.
Counsel, did you have any role in this matter, the underlying landlord-tenant matter, or anything that has to do with this matter other than as an attorney?
I did not. I was the attorney of record, signed the complaint, and frankly, I believe the record showed Ms. Dean did not even participate in that underlying landlord-tenant claim. So I didn't even have any conversations or communications with her through that underlying landlord-tenant case.
All right, the motion for summary disposition will be granted at this time under MCR 2.116C8. No factual development could support the claim that is being asserted by the plaintiff in this matter, and for that reason, the motion for summary disposition will be granted. I would have to make the finding that the defendant was counsel for someone that Ms. Dean may have issues with, and certainly as counsel, he's indicated that any actions that were taken pursuant to court orders as it relates to the eviction. And for that reason, it certainly would not adhere to the responsibility on the attorney's part, as the attorney would not be able to act without color of law, i.e. without an order from the court. And that such order would not allow an attorney to take action, it would allow the bailiff to take action. So the motion for summary disposition is granted, and the case is dismissed with prejudice as it relates to Mr. Butchart.
Thank you, Judge. Did you want me, Your Honor, to submit I can submit it on a SCAO dismissal form and just indicate in the further orders that the motion is granted pursuant to C8, or would you like some other document?
That would be fine if you do it that way, counsel.
Okay, very good. We'll get that to you today, Judge. Thank you.
All right, this is case number 23158736. This is Midland Credit Management Incorporated versus Atisha King. The matter is before the court on the filing of a motion to set aside a default judgment in this matter. The record should reflect regarding this matter that the judgment of this matter was entered by default on February the 15th of 2024. The default amount is $6,329.39. The court did receive a petition to set aside the default of this matter on or about January 9th and set the matter on for hearing on today's date. For Midland, your appearance at this time, please.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
All right, Mr. Kuipers, your P number, if you will, for the record, sir.
71348.
All right, thank you, Mr. Kuipers. Good morning again to you. I'm looking now for Tisha King. If you're on the Zoom, please say something at this time.
Yes, I'm here.
All right, thank you, and good morning to you, Ms. King.
Morning.
I did receive your motion regarding this matter to set it aside, and a part of your claim in that regard is that this is a matter of identity theft. Is that what you're alleging, ma'am?
Yes.
And you did submit to the court a police report that you filed. It looks like that report is dated the 3rd of May of 2023. Is that correct, ma'am?
That's one of them.
And I do see another one in 12/28 of 2020, correct?
Correct.
All right.
That's still
All right,
one of them.
thank you, Mr. Kuipers.
Your Honor, yeah, so this is defendant's motion to set aside a default judgment. I mean, I know this is the second one. I understand she was unable to appear at the last one due to other issues. I'll leave it to the court to handle or deal with that. But as for the outstanding motion to set aside the default judgment, I would just give the court a brief history here. So this summons and complaint was served by alternate service on December 5th at the same address that the defendant listed on her motion to set aside the default judgment, which is the Charlotte address. So I would note that service was proper, and I'm not hearing good causes to why the defendant didn't file an answer. Furthermore, I'd also note that that is the same address that's listed on all the invoices on this underlying Capital One account. The plaintiff is also arguing that there is no genuine material fact and no meritorious defense here. So for all those reasons, plaintiff would request that the judgment stand under MCR 2.603.
All right, thank you, Counsel. The issue, of course, Ms. King, that's being raised is that the notification that was made was allowed by this court by alternate service first class mail. And the address that everything was sent to was the Charlotte address that is, I had to do some things, so I'm going to set that up, make that okay now. All right, this is case number 24-160270. This is Credit Corp Solutions versus Chantel Billingsley. The matter is before the court, set on for a status conference. Looks like this is the first hearing regarding this matter. Your appearance for the plaintiff in this matter, please.
Judge, may it please the court, I am attorney Richard Bruce, and I'm the attorney of record for the plaintiff, and my bar number is 35222.
All right, thank you, counsel. Good morning to you. I'm looking for Chantel Billingsley. If you're on this Zoom, ma'am, say something at this.
Hi, can you hear me okay?
Yeah, I hear you fine, Ms. Billingsley. Good morning to you. Thank you for your patience this morning as well, ma'am.
Yeah.
All right, counsel, I don't know if the parties have had an opportunity to talk about this at all. That might be helpful. Tell me, have the parties talked, counsel?
No, Judge, but for the defendant's answer and the verification of debt letters I sent her, I have not spoken to her personally.
Your Honor, I pleaded with this man by mail. Every company that was on that paper, I pleaded by mail, certified mail, and to you too. Also, I haven't heard anything from this guy here. I don't even know who he is. I never did business with him.
Yeah, well, he's the attorney for Credit Corporation, and anything that you sent to the court, I'm sure that we have it. I have your answer and everything. My question is whether or not the parties had talked about this for purposes of trying to resolve the amount by some settlement or whatever. But it does seem to be a disputed matter, so I will set it up on my pretrial schedule. I will open discovery on this matter, allowing the parties to exchange information as allowed by law for the next 60 days with a return date of 5/28/25 at 9:45 a.m. That's when the parties will be returning to court. I am going to send out a scheduling order. That scheduling order allows for discovery over the next 60 days. It also allows for various provisions for filing motions, and it sets the next date for the parties to do something that is not relevant to this case. I believe you. I believe that somebody is using your identity. I believe that somebody is because you got police reports back to in 2020, and you got police reports from time subsequent to that. So clearly somebody is using your identity. That's not the question I asked you. And you wasted my time when you answer questions that I didn't ask you. The question I'm asking you has to do with why you did not timely respond to the complaint. And you did not. You did not. And I thought that you'd have, I thought that you had some reasons that you can give me as to why you didn't respond to the complaint that was sent to the Charlotte address. The best that you can give me is that, no, don't, you put your hand down, man. The best that you can give me is that you were living at another address, and oh, by the way, you never got it, even though this is your address. That's problematic, because that's prong one of the test. Prong two is whether or not you have a meritorious defense. You pretty much have convinced me that you may very well have a meritorious defense on this matter. Let me come to counsel. Anything further, counsel?
No, Your Honor.
Ma'am, let me ask you, you said that there was a period of time, that you were sick. Well, what year was that, man? When was that? You got to come off of mute, man. Come off of mute.
I've been sick for the last 8-9 years with lupus.
All right, well, I understand that, but you were talking about a particular period of illness. I know that lupus is an ongoing thing, but during the time, I'm specifically getting at when this complaint was filed and so on and so forth in November or sometime in 2023. Were you hospitalized? Anything? Do you recall any of that?
Yeah. Yes, I've been hospitalized. Yes, seriously.
During that period of time?
I've been hospitalized every month for 1 week for 2 years in a hospital with IV fusions, kidney issues. Yes.
All right. All right, thank you, ma'am. All right, the court has listened to the argument on the motion to set aside the default judgment in this matter. The test is a two-pronged test pursuant to the court rules, and the first part of the test is whether or not the plaintiff, or strike that the petitioner, can demonstrate good cause for the failure to respond timely to the complaint. That's a critical part of the test. The second part of the test is whether or not the defendant is able to indicate that there may be a meritorious defense to the claim. On the second prong is rather easy here, because the defendant indicates that she has some identity theft issues going on, and she's filed a couple of police reports in that regard. So it's first-class mail regarding this case, and you did not respond to the entry of default back in February. Strike that January of 2024. You didn't respond to the entry of default judgment, nor did you respond at various other times when other documents were being filed. So the first prong that the court has to consider is whether or not there is good cause for your failure to respond within the time permitted by law. Tell me about that aspect of the case.
Are you speaking to me now?
Yes, Ms. King.
Okay. Oh, I'm
Yes.
just trying to hear you. It's going out. So the reason why
Sorry, if you can't hear me, if I'm talking and you can't hear me, please say something, because I need you to hear. And that's a critical part of this. The attorney in this matter is arguing as it relates to the two-pronged test that you have to meet in order for the default to be set aside. One is that you have to show that there is good cause for not responding to the complaint in the time permitted by law. That's the first step. The second step is that you are able to demonstrate that there is a good cause for setting aside, that there's a meritorious defense that exists if the default is set aside in this matter. So dealing with this first prong, as I indicated to you, raises some concern with me because I know that the complaint was sent to your address on Charlotte Street back in January of 2020. Strike that in October. I'm looking at my documents here. November of 2023. That subsequent to that time, default was sent, judgment was entered, et cetera, et cetera. And you're just taking action in 2025 in relationship to your motion. Why didn't you respond to the complaint in the time permitted by law? Talk to me.
I did respond. I sent something to Midland. I also have another address where I lived at in Novi during this time, but I've also always had this townhouse here. I responded to Midland, and I asked them for.
It seems clear to me that there is an identity theft issue that may be associated with this case. But she has to pass the first test. And the first test is whether or not there's good cause for the delay in this matter. And while there is not, in the court's view, an overwhelming amount of good cause, and the claim that nothing was sent to the Charlotte address is disturbing to the court, because I have proof in the court's file of things having been sent to that address, and that is the address for Ms. King. Given the fact that she raised with the court on another occasion that a part of her difficulty in responding to this was secondary to illness that she has suffered, and that she has a chronic illness that she deals with. With that in consideration, I believe that the defendant has demonstrated enough good cause for the delay in responding to the complaint. So in one sense, you narrowly passed that particular test, and not because I don't want her to pass the test or because I want her to pass the test, but because that's the rule. That's the rule. You could very well be. All right, the court now calls case number 23-163-175. This is Samuel McClendon versus Randy Linefield. The matter is before the court on a petition to show cause. The defendant previously did not appear for a hearing on a subpoena, and the court set today's date for a show cause hearing. Do I have Samuel McClendon, please?
Yes, sir.
All right, thank you, Mr. McClendon. Good morning to you. I'm looking now for Randy Linefield. Randy Linefield, if you're on this Zoom, please say something at this time. All right, it appears that the defendant has not appeared regarding this matter. I'm looking at the document now regarding issues of proof of service. Just one moment. All right, so Mr. All right, it appears that Mr. Linefield has not appeared regarding this matter. For that reason, the court will find that the defendant is in contempt of this court for failure to comply with the court's order. Accordingly, the court will issue a bench warrant regarding this matter. Bond will be set on the bench warrant in the amount of $10,000. Sir, you may submit your bench warrant application to the court. It's a form that you need to fill out and get to the court. The court will sign off on that warrant, and you take it to the City County Building, 17th floor, the county sheriff's office after it's signed by me, and then they'll take it from there. Understand, Mr. McClendon?
Yes, I just want to make sure. So you said submit the benchmark to the court,
Bench warrant, yeah.
bitch warrant to the court. Okay. And is there a certain time that I have to do that by, or is that time sensitive at all?
You want to do that as soon as you possibly can, okay? Get that
Okay.
form and get it sent to Judge Coleman. I'll get it signed up and get it right back to you so you can get it to, so you can take it to the county sheriff's office.
Okay.
All right, sir, I wish you well.